back to the House Judiciary Committee this Wednesday afternoon, February 25th. We're going to our attention to H171, and we're going to start with the walkthrough. Then we have some witnesses. Over to you, Michelle. Thank you for being here.
Thank you. For the record, Michelle Childs, Office of Legislative Counsel. I'm looking at H171 as introduced. I just wanted to start out by saying, like the bill this morning, this is another one that I did not initially draft, but have picked up for this year. So I don't have all the necessarily the background information. Again, I'll point out that you might we go to the draft. So it is at least from a language standpoint, and it's pretty straightforward. So you're working in Title III in the chapter having to do with the Attorney General's office. And this bill has to do with providing some guidance to the Attorney General's office around investigations of officer-involved shootings. So if you look at the language on the first page, Section 1, adding a new section to the Attorney General's chapter. Definition section, we're using definitions that are already in with regard to your definition for law enforcement agency and law enforcement officer that are already codified in Title 20 in your public safety title. Look at page 2, subsection B, is that the Attorney General may commence an investigation, so it's discretionary, it's not mandatory, into any law enforcement officer who unholsters a firearm in the performance of the officer's official duties. So I just wanted to point out that as it was originally drafted, so it's called an act relating to Attorney General investigations into law enforcement officers' use of a firearm, but the language that is in here is around unholstering a weapon. So I don't know, and we have the benefit of having a sponsor. Well, I don't know whether or not that was intentional or
it was an oversight by me, and that was corrected by Representative Oliver over there. And I believe there's some language to replace that.
Okay, sure. I just wanted to point out, and just we can do whatever you want. I just want to be clear on the policy when we do it.
Whoops, here.
So subsection C in subdivision 1 is that any investigation commenced pursuant to this action is to be completed within 90 days after initiation, although there is an exception in subdivision 2, which is that an investigation can exceed 90 days when the incident investigated involves multiple individuals who were either shot or physically injured by the law enforcement officer's use of a firearm. Subsection D is that during the course of the investigation, the Attorney General's office has the responsibility to prepare and submit a written report to the officer as well as the officer's law enforcement agency that employs that officer. You'll see in the subdivisions D1 through 3 things that the report has to contain at a minimum, which is a statement of facts, a detailed analysis and conclusion of each investigatory issue, and any recommendations concerning the filing of any criminal charges and proposed changes to law enforcement policies that may be at issue. Subsection E is a directive to the Attorney General's office to adopt rules with regard to this particular section. And those rules have to include the standard of review for any investigation commenced pursuant to this section, and timelines to review each incident investigated. On the last page, on page 3, also ensuring public access to information concerning the procedure and timelines for any investigation and any other considerations that the Attorney General's is necessary. And as because it was something that was introduced last year, it does have an old date, effective date, but if you decide to proceed, wouldn't be that.
Any questions? Go ahead.
So because this bill is proposing to create an investigatory requirement for the agent's office, does that mean, so right now with investigations that are being done, what is compelling those? Is there something compelling those investigations?
I think probably your witness from the Attorney General's office can talk to you about how they make those decisions. Generally we see the Attorney General's office getting involved oftentimes when there's a conflict within a county, and it wouldn't really be appropriate for a state's attorney to be looking into investigating officer that they're working with directly all the time.
Yeah,
But I think in terms of the protocols and when, how they go about doing the investigations, how long it takes, how, if they have to, how complicated it is, do they have to bring in expert witnesses, or is it, pretty narrow
Yes.
scope of investigation? And I think hopefully Todd can talk to you about those things.
yeah, excellent. Okay, thank you.
Any other questions? It's pretty straightforward, so we'll go to some other witnesses we have Joe Porro and Jeff Bauer. Okay, yeah.
Jeff, if you want, we were supposed to have an officer here from Rutland or invited in series of events and they couldn't make it, but if you wanted to sit up there also in the witness chair, I'm sure I know you have things to add potentially, so if you both wanted to go up there.
Yeah, that's great.
That would be great.
You can go after Joe.
Want me to speak separately or was I?
You can speak separately.
Yeah, you can do, yeah, you can
Okay.
separately. Yeah, okay, great.
So that works too.
Can you take a time out for 1 second?
Yeah.
In recess.
We'll stay live. Just since we're a bit of a preview, couple things. I did get the budget memo over to appropriations. And also at 2:00, we're gonna have to switch over to this other bill because that's when Judge Bonnet is available. He's probably gonna take a few minutes and then we'll go to Julio and then we'll swing back around to this since we had a little bit of a late start.
Yeah.
So we may be pushing Todd back again, but we'll see.
They have to fight House Joe, which I'm game for.
All right,
We can take House Joe.
Yeah, let's
Okay.
say that.
We'll put Todd up against them. All right, over to you if you got yourself for the record and proceed.
Good afternoon. My name is Joe Coro. I serve as the president of Vermont Fraternal Order of Police State Lodge. I represent 322 law enforcement officers across the state of Vermont. We are an organization, the Fraternal Order of Police, of about 400,000 members throughout the country. I've been a police officer with the Brooklyn Police Department for nearly 12 years. I spent my first 9 years assigned to patrol, where I served as a field training officer. Continue to teach patrol procedures focused on officer safety tactics. I'm currently assigned to the Detective Services Bureau, specifically in the drug unit. I serve as a team leader on our emergency response unit. I'm also the immediate past president of the Burlington Police Officers Association, FOP Lodge 21. During my time in that role, I was involved in multiple critical incidents that were reviewed by the Attorney General's office and assisted officers as they navigated that intense and difficult process. So I appreciate the opportunity to speak on this issue. I want to begin with accountability and transparency specifically. Law enforcement officers are held to a high standard every day. It's no surprise. Everybody knows that. We're expected to conduct thorough investigations and bring them to a timely conclusion. In my current assignment, even high-profile cases are expected to move forward once all available evidence has been collected, with limited exceptions, such as long-term narcotics investigations designed to build stronger prosecution. Most major crimes are investigated and resolved in a matter of months. We also have to recognize that cases submitted to the Attorney General's office following a critical incident are complete investigative files. They may require some follow-up, but overall, they are complete investigative files. They have cooperative subjects and witnesses. Evidence is generally all there for them to review. Thoroughly vetted, supported by physical evidence, typically involve, like I said, cooperative witnesses and subjects. The Major Crime Unit of the Vermont State Police consistently conducts professional and thorough investigations of critical incidents statewide. Historically, those investigations were submitted to the Attorney General's office and resolved within a few months at the extreme. Prior to 2020, it was common to see officers either cleared for duty or formally charged within approximately 60 days. So previous, I can go back to our current Chief Burke when he was involved in a officer-involved shooting back in 1998, I believe it was. 48 days was when he received his answer. I will fast forward to 2 years or a year and a half after I became a police officer. An officer that I went through the academy with, who I was good friends with, he was involved in a shooting in Burlington, downtown Burlington. 55 days is how long he waited for an answer. Whether you, that was 2015. So, and then we got to 2020 and past 2020, that has completely changed. Officers across Vermont often wait close to a year for a decision now. During that time, communication from the Attorney General's office is minimal. I want to be clear, I'm not here to badmouth the Attorney General's office. I'm just stating the facts that I'm seeing from where I'm standing. The perspective of the law enforcement community is that this creates an appearance of a double standard. So officers are expected to work efficiently, meet deadlines, provide regular updates in the course of their duties. Yet when their professional standing and potentially their entire future is at stake, they are frequently left without meaningful updates for extended periods of time. Accountability and transparency must apply consistently across this system. There are practical consequences to these extended review timelines. Officers placed on administrative leave to start with, later moved to restricted duty, do not receive the same level of training as full duty police officers do. While on leave, they receive zero training. In the year since 2020, community leaders have consistently called for better trained police officers. Prolonged review processes directly undermine that goal. Policing is a profession built on repetition, judgment, and experience. When officers are sidelined for extended periods, critical skills degrade. I see this personally when I step away from patrol. So I work generally in the drug unit right now in plain clothes. On my own choice, I attempt to work 5 to 10 hours of patrol a week if it's available, because I know how quickly my skills degrade if I don't do that. And it's very obvious. You can see it in a month of being in a role like that, how fast things just kind of disappear for you. Like, you have to continually be doing the things to stay up to date on. It's very easy to forget stuff. There's so many things, as you all know, that we're trying to stay up to date on. It requires you to be in it at all times as much as possible. So, sorry, I just lost my place here. Yeah, sorry. So I see this personally when I step away from patrol. Constant immersion sharpens performance, and the current process works against that principle. Retention and recruitment are already significant challenges in this profession. You can say it across the country, but specifically in Vermont, it is a free agency in Vermont right now. It is what agency is going to pay you well, where are the benefits, where are the support, all of those things matter, right? And it is very much free agency. You can jump from PD to PD because we are a statewide jurisdiction. We all go to the same police academy. So it's easy to move from place to place if you want to. And generally, a lot of agencies fall under Beamers. So you can just move your pension back. Your pension doesn't go anywhere. It's just move place to place. You still have the same pension. So we very much have to focus on recruitment retention. Specifically at my agency, we lost 40 police officers after 2020. Between 2020 and 2023, we have not recruited those people back, and our retention is poor. So we are struggling in that sense. And when I look at, if I'm a prospective police officer thinking about joining a police department and looking at the states, because I don't have to stay here, right? I can go other places to work. This is something that, first of all, if you're talking about lateral, so somebody from another state coming here is going to consider, they're going to look at this type of thing because this has a huge impact on their life. A new officer is going to take the time, is going to be looking into these things. And if I can go to New Hampshire and be cleared in, say, a month or 2 or 3 months, or I can come to Vermont and possibly be sitting on sidelines for a year, those are very different things. And I'm going to go with the one where I don't have to worry about that scrutiny for that entire amount of time. And that scrutiny that I'm going to have on myself, not just the scrutiny that can come from everyone else. So getting into that, though, we're talking generally about, officer wellness. And I think I heard you talking about it earlier, heard it being talked about earlier, but I do think in this specific thing, it is overlooked. When this happens, the officer wellness is completely overlooked. So just going back to the prolonged waiting period, my department itself has lost officers during this prolonged waiting period. And I'm concerned that continually, if we keep doing this, we're just going to keep losing people in that process.
Here.
Thank you. I apologize. I just
No,
want to hear
absolutely.
what you're saying in the appropriate context.
Yes.
Because what you're describing is current state, right? And I guess my question is, what is the guideline or statute, or is there any for current state of how these investigations are done?
The way
Is that what we're trying to create here, or is there something
Yes.
that we're working with?
what we're trying to create is a clear guideline and timeline that can be followed for the process. And right now, from where we stand, it appears there is no guideline or process. It's just your case goes from the state police to the Attorney General's office, and then it sits at the Attorney General's office while they do what they need to do there. While it goes to experts if they choose to do that. And when that ends, we do not know.
And is it for because in this one, it's very clear that it's when a firearm is unholstered. Is there a line of like, these cases go to the Attorney General's office?
So I want to be clear, and I passed forward some language. That portion I would like to see changed.
Yeah,
The language I would be speaking to is more around the lines of when an officer discharges their firearm, the commission of their duty, when someone is injured in that incident, like those types of cases, which are generally what go to the Attorney General's office. We can think to officer involved shootings, the tragic individual that was hit on Shelburne Road and was killed in that incident. That was not a officer involved shooting, but that would have been a critical incident that then was reviewed by the Attorney General's office. So it kind of depends.
I think just if I can understand, you're saying there's not really a structure, at least that you're aware of. And so this bill is trying to put a structure in place, or at least make it transparent.
We're going for some transparency here, as well as a guideline and a timeline. So when I say to an officer as a union rep, here's how the process works. I can give them an outline of the process right now, but I cannot give them a timeline at all. I can't even give them the most of the timeline I can give now is it's going to take probably a year. That's my guess. From everything I've seen over the past 5 years, the year is the average right now.
Thank you. Just helpful.
Yeah, absolutely. Please, I'm happy. I'm just reading through this because I want to get some of these points across, but I want to answer questions. I won't have that feedback.
I got one question.
Yes.
So number of years ago, it was 40, 50, 60 days, whatever.
Yes.
And then around 2020, which is COVID time, that's the time, was it COVID issues that you think made this change, or?
I do not,
I
but
gotta believe that if we were still around, the 50, 60 days or even 80 or 90 days, we probably wouldn't be here.
I would not be sitting here right now having this conversation.
Right. And so I guess, how did COVID change it?
I would let Attorney General's office speak to that if COVID did change it.
Okay.
I'm not convinced that COVID was what changed it. But I'm not going to speak to something that I don't know the answer to.
Right.
So I will let another expert on that speak to that. So, just going back to officer wellness. So I'll walk you through kind of a quick example. In a lethal force incident, an officer responds to a rapidly evolving threat, makes a split-second decision, then immediately enters this process, which is very intense and can be very isolating, especially at the beginning. They're removed from the scene, taken to a hospital, photographed, separated from their equipment, and transported home. Within days, they'll sit for a detailed interview with Vermont State Police Major Crime Unit. And then from there, prior to that, they're already placed on administrative leave. When you're placed on administrative leave, you are barred from your workplace for a period of time. And ultimately, you're restricted from full duty until you're cleared by the Attorney General's office. I'm giving you a very truncated description of this process, but what follows is the important part. It's the months of uncertainty, and every day, even when you believe your actions are lawful and justified, you just relive this incident over and over and over. I myself have never been through that specific critical incident, but I've been through enough incidents in my career to know how many times I've replayed certain incidents in my head to see if there was a better way to do it. And that being the case, it's incredibly jarring and it's incredibly tough on your mental health as you continually go through that process. So you continue to analyze it over and over and over. You're questioning every decision you make. You're waiting for an outcome that may not just alter your career, your reputation. It's going to alter your life. And it already has, to a point that I cannot fully explain. That trauma of having to take somebody's life or even seriously injure somebody in the commission of duty, that stays with you no matter what. But let's add on the other side of it of not knowing how this is going to end for that officer. So the isolation in the beginning is incredibly real. And there's still an isolation that goes through it even after you've had time to give your interview and all of that, because you still feel very isolated from everyone else. You're the one dealing with this and you don't know what the outcome is going to be, and nobody can give you an answer, which we understand. That's the way it works. There's a process that has to play out, but that process cannot extend for 300 days. There has to be a way to shorten that process. The big concern I have when it comes to officer wellness is what are we creating there? Well, we're creating a risk of dependence on substance use, creating a risk of not using good coping mechanisms. We may be creating a risk of suicide. And if you know anything about law enforcement, officer line of duty deaths, suicides are double to triple the amount of line of duty deaths. So I don't want to increase that by a process that can be worked. We can collaborate and come to a solution for this process, especially when there's other states to model and to look at that are doing this in a reasonable amount of time.
The other states have a statute with timelines.
I cannot tell you that. I can just tell you that I know from experience that other states' timelines they're a lot faster with the timelines. There obviously are certain states with a full agency directed to do this all the time, and they are able to clear incidents in 3 weeks. But I'm not speaking to that because there's a lot of states that do not have that and are still able to do this in a reasonable amount of time. I do not consider 300 days. I don't even consider 7 months a reasonable amount of time unless there isn't some serious extenuating circumstances. It's just too much time for somebody to sit and wait for an answer. That may mean it's one of two things, right? I'm justified in my actions and my career continues. I'm not justified in my actions. I'm being indicted or charged. And my whole life is about to change completely. Those are two very different things.
Ian.
Thank you very much for your testimony. Really, and thank you for taking our questions.
Yeah,
An officer needing to be taken off of patrol duty when there's an investigation pending, where does that requirement come from?
That they have to be on leave.
Yeah.
So the way that it works is this is until it's completely resolved. This is a criminal investigation. So they can't continue to perform their duties while they're being investigated for a criminal investigation.
And is that like a statute that obligates that, or a policy, internal policy, or?
Generally for us and for all agencies, it's internal policy. I would have to pull the statute to see if it specifically speaks to that in there.
Okay.
So, but it is an internal policy that when you're involved in a critical incident, you're placed on first administrative duty or administrative leave, and then eventually, after a certain amount of time, you'll be brought back at least an administrative duty function.
And that determination about like how long they're on leave to how long they go to administrative duty is also like an internal policy.
That's a very much usually an internal decision in general.
Yeah.
It's that I will tell you there's not a policy specifically states how long it's going to be at our agency. It's mostly based on them having had good services, and then also if they're ready to come back and if there's work for them to be able to do at that time period. Yeah. So we ask officers to confront violent and chaotic situations on behalf of the public. When those situations result in critical incidents, we owe them a process that is thorough, fair, transparent, and timely. Delays of this magnitude serve no one, not the officer, the agency, or the community. If we're serious about accountability, professionalism, and public trust, we must ensure that critical incident reviews are completed with both rigor and reasonable speed. Our officers deserve clarity, and our community deserves confidence in the system. The integrity of this profession depends on that. I just stand by the fact that we need an established timeline that provides updates from the Attorney General's office. If my stance on this is, and this is my opinion, 90 days, if you get to 90 days and you still have not come up with a solution, there's no answer. Every 30 days going past that point, the AG's office should be passing along an update to the employer and the employee where that sits, what the status is, what's happening next. And I know one of the holdups, heard it through a couple different people, I believe it to be expert testimony or expert witnesses. State police has been given the authority to conduct these investigations. They have the ability to view with a reasonable standard. They are police officers themselves. Their findings can lead you to if it's justified or not. From that point, if you need an expert and you cannot get one in a reasonable time, it may be time to consider for the state an expert in-house, like a position that is their sole job. And then, branch out on that as you will. You have that expert in-house. If you don't feel that that there's not enough things for them to be doing, there's a great place for them to do training, at the academy and things like that. But if that is the holdup here, the holdup is that we need an expert to review almost all of these cases, then an in-house expert would make the most sense to me.
Thank you for this question. I don't know if you would have it, or maybe you just know where the information would be. Is there data on kind of, and I'm not going to know the correct wording of things, but these investigations and like how many are resolved in under 90 days, how many are after? Like, is that something that we have access to and we can see?
I don't know of a place that keeps the table of data showing like this incident was investigated. Maybe it is on the Attorney General's office website or somewhere else that lays out that exactly. I can just go off of all of the ones that I know at our agency and outside of our agency that have been over 300 days.
I just feel like that is important for us to have, not to say, do not believe you, but
Yes,
to have
I
that
agree.
accurate information. And if we're
Yes.
going to change something,
Yep.
then to be able to measure, did what we do actually lead to fewer below 90, whatever the threshold is.
I
So,
think you may be able to ask that question in a different way of asking how many of in the last 5 years have resolved. You can say under 90 days or under 6 months, it's probably a shorter list.
okay, but there's not a place where that data is. So-
Not that I know of, doesn't mean there is not.
I full-heartedly agree with Representative Dolan's point. I just think having the data and having that additional transparency in this process, even for the sake of accountability, and guaranteeing an expeditious review on these cases, it's really critical. Even if the data doesn't exist in the consolidated place, and I'm sure that the Attorney General's office will comment on this, maybe it's something that we can require in this bill. Before I go to my line of question, I just want to say thank you to you and your officers for your service to our state and all states. I really appreciate it. I think something that a previous witness brought up in terms of officer wellness was a really important point that wasn't something that I had in my line of questioning coming into today, but I think it's a really important takeaway that I personally taken away, and I'm sure that other colleagues on the committee are taking away as well. Something that we need to consider when crafting this legislation to make it the most effective that we can. Something else that you spoke about, even beyond officer wellness, the officer that's involved in the shooting, in their wellness, in the line of duty and in the workplace, but also their families. And I think that's something is that, behind every man and woman, that wears the badge, there is a family that's in turmoil behind this, not knowing, are they going to keep their job? Are they not? There's media scrutiny that's involved in this. I mean, this is a very public thing that very few of us experience. And so I just, my heart goes out to those officers that are dealing with this on the front lines, because it can really uproot someone's lives. And I think anything that takes over almost a year, 300 days to be resolved is wholly unacceptable. Wholly unacceptable. And, that's why we're all here in this room, is to hopefully provide clarity and transparency in that. To my question, specifically looking at the 90 days, do you think that is a long enough time frame? Do you think it could even be shorter?
I will give the 90 days as like the longer portion. 60 days was the average before. I guess my question would be, what changed? What are we doing different now than we were doing before 2020?
Right.
That's what I need to fully understand. And I'll tell you right now that I don't fully understand that, and I want to understand that. But even if that is the case, there's got to be a way to shorten this window, because this is incredibly too long right now.
Yeah, and I would just say, even from my experience, seeing some of these things, not officer-involved shooting investigations, but in corporate America, if you have insider trading allegations or other instances where someone's being investigated for misconduct, I can tell you they're ruthlessly efficient. I mean, it could be 24 hours and someone is out the door, or it's resolved within 24 hours, right? There's no wrongdoing that's been found. My other question is looking specifically at the Attorney General's office. And I'm curious if these investigations are actually, you talked about your belief that it would be great to have an expert witness in-house with the Attorney General's office. Are those currently being reviewed in-house? Or are these being exported to other states? Can you just kind of talk, to your knowledge, can you talk about what that process currently looks like?
To my knowledge, I understand that generally most of these cases that they consider not straightforward enough to be able to resolve and to review and come a finding to, I generally understand that it goes to, forget his first name, but Daigle's his last name. I've seen him present. He's a lawyer who takes on these cases and does an expert witness. He's been involved in more than I can count at this point.
And I take it he's not in the state of Vermont.
He's not, no.
He's not. Okay. No, thank you.
Did you have more, or you just?
That is all I have.
Yeah, that was a lot.
I know.
Thank you very much. So I really appreciate that. That's very helpful, very helpful. So I really appreciate it. So Jeff Bauer, do you want to add anything? Please identify yourself for the records, have a seat.
Yes, my name is Jeff Bauer, born and raised in the state of Vermont. I'm a police officer in the city of Burlington alongside Detective Coral.
Thanks for being here.
Absolutely, it's my pleasure. Thank you for having me. I work in the patrol division at Burlington Police Department. I apologize, I didn't come prepared with anything written down. I came here more as an observer. I have firsthand knowledge in this situation.
Right into the fire.
I don't mind. I don't mind if I can be helpful. A little bit of history about myself. born and raised state of Vermont. My father's a now retired Burlington police officer, was an officer in Arizona as well. So I grew up kind of in the halls of the Burlington Police Department, if you will. I've worked for a year as a police officer in New Hampshire as well. Have a little bit of experience in law enforcement outside of Vermont. Previous to that, I was in the military for 8 years, in the Marine Corps as an infantryman, served multiple combat deployments. So adversity in rapidly developing situations aren't exactly new to me coming into law enforcement. I'm not going to speak about the specifics of my case, but on August 9th of last year, I was involved in a situation in which I discharged my firearm at a subject. That night, like Detective Coral explained, photos of me and my uniform were taken. My gear was all seized as evidence. I went home and even my boots. I went home wearing Crocs and shorts that night. I had my interview about a week later with state police, and now almost 7 months later, I've not heard a single word as to where I am in this situation. Luckily, I have a pretty good support system where my father kind of understands. My wife cares a lot, but I'm sure if you brought my wife down here, she would say that it affects us at home. I consider myself a pretty tough person, but there are definitely days where my mind goes like the worst possible candidate scenario. Like, what if I do get charged? What happens to my life then? What happens to my wife? What happens to my house? And there are moments where my anxiety seeps up and I have to step away from what I'm doing for like 20 minutes and just breathe and remind myself that we'll get through this one day at a time. I have personal vested interest in this bill for that reason. Having been a cop for 9 years, I've been involved with homicides. The Red Square murder was mentioned earlier in the previous case. I was the second officer on scene for that. I've been involved in not a detective, but I've been involved in some pretty complex investigations. And I've seen situations in which the state attorney's office can do a two-way on a homicide the next day. I personally would like to see some form of timeline so I can have some sort of correspondence or answer in less than 7 months. Because in the meantime, I'd like to think I make good decisions and I'll be cleared, but ultimately I don't know until I get that green light from the investigating body. The investigator from the state police kind of let me know where he's at. My interview was the last piece of evidence he needed for my case. And he said he was presenting that to the AGs, if not that day, the next. And that, again, that was back roughly a week after August 9th, so mid-August. I have not had an update since then. So I can tell you firsthand, it's put a lot of strain on myself and my wife. I'm sure there's days where I've been very grumpy with her unintentionally. I think she does a good job of understanding that. Luckily, I have that support base. When I got into my situation, I conferred with an officer who used to work for us. It took, coincidentally, his badge number 355 days for him to hear back correspondence. And in that time, he left law enforcement entirely in the state of Vermont. I don't know if that was solely the reason why he left, but that's definitely a factor, according to him, that played into him leaving law enforcement. It is very much so a strain, and I don't mean to speak for all officers in my situation, but I got to imagine they probably feel a very similar sentiment that is a overwhelming burden. There's days where I'm fine completely for days in a row, and I can put it on the back burner and not really think about it. And then randomly it'll just pop at the forefront of my mind, and then I'll sleep that night. Even after my incident, because it's an active investigation, you can't speak to anyone about it here until your interview is on that week later. So for that 7-ish days, whatever, I can't even talk to my friends about it. I'm at home just wheels spinning, thinking about the situation by myself. I can't even confer with my dad about it, who was a law enforcement officer himself. Unfortunately, that part, there's nothing you can do, but the part that comes afterward, when the investigator from state police told me that my interview was the last thing he needed, and that was back in mid-August. When I investigate a case, it's expected that I have my evidence turned over. There's never a timeline, but in an expeditious manner. And maybe there is on the other end of my situation now. It just doesn't seem that way from where I'm sitting. I don't mean to unload my emotions on you guys here today. I just figured it out off of my human side of things to this bill.
Yeah, it's very helpful. Very helpful.
I'm also open to questions, just if you don't mind, not about the particulars of my incident.
Yeah. Any questions? Zach?
I'll start with one. Jeff, thanks for coming in and thank you for your service. And I'm very sorry that you're going through this. And again, just tell me if this is not a direction that you can go in, and that's fine. But I think one of the things, I mean, I assume that you're very supportive of the 90-day time frame.
I am.
It certainly is better than 300+ days in waiting in limbo.
Absolutely, yes.
And, I just think, if I were to put myself in your shoes, right, and this happens mid-August, you think you at least have finality in the process. You're waiting for a response, holidays go by, birthdays go by, maybe anniversaries.
2 weeks prior to my wedding.
Yeah.
Difficult,
I can't imagine. And so all that said, I'm wondering if you, during this process, if you're allowed to have correspondence with the Attorney General, if the Attorney General's office has, no communication's been had from their office regarding your incident. But I'm wondering if, you said the investigator told you that, this was kind of the last step in the process. So it seems to me that you've been waiting for, again, 300+ days for the next shoe to drop. Is that a fair
Yes.
disclosure, right? Either way.
I've gotten no correspondence after state police said they're giving it over to the Attorney General's office. So I have a timeline of when they received the case, according to a state police investigator. I don't know if this eyes been laid on it. I understand it's been outsourced to Dago Law Group in Connecticut.
Right.
That's also coming from the state police investigator. Other than that, I don't know where my case lies.
And I'm wondering too, do you feel like you have the resources you need, from the beginning of this, just to handle this, in the department?
I particularly, I didn't really look for those resources. I kind of avoided those, I'm gonna be honest, just because I have my own.
You have a great support
I
system.
have my own support system I prefer leaning on.
Yeah.
I don't really confide in strangers, even if they are an expert in their field.
Right.
I prefer confiding in my own family.
Right.
Do those resources exist? I believe they do to some extent. I know of at least one former trooper who owns a first responder wellness society agent in the county. I don't know if I answered your question much.
No.
I think the resources are there if I were to seek them out.
And
Yes.
that's what I was wondering. It's just to make sure that, if there are other officers who are through a similar incident that don't have the great support system that you have, to make sure that they aren't feeling isolated and alone.
Even with those resources being there, I think the feeling of isolation comes from so few officers in Vermont are put in a situation where they discharge their firearm in the line of duty.
Right.
And oftentimes those are going to be the only people who understand exactly what you're going through. They might have a good concept of it working that line of field, but until they've been truly in that situation, they're not going to truly understand what that's like. And even with those resources, I feel like it would be difficult for me to confide in them, knowing they don't quite understand that situation the same way. And like I said, luckily is a weird word to use. Someone else had come for me in that situation within the last couple of years. 2022, I think, was his incident in which I went to him for guidance on what happens next. And he told me the same thing. For 355 days, he sat in silence until eventually he had left the state and got a phone call one day.
Well, thank you and hang in there.
I appreciate you. Tony. Thank you very much. So we will go to Todd Delas on behalf of the Attorney General's office next. If you could join us. And no. Judge Zoney is going to weigh in on H849, but he says his testimony is very short. He has a hard stop at 8:45. So I think if we get him in at 2:30,
8:45.
8, whatever.
I know, I was confused.
2:40.
Okay.
Over to you, Todd.
Good afternoon. For the record, Todd Delos, Assistant Attorney General at the Vermont Attorney General's office. Before I start kind of the bulk of my testimony, I think it is really important to appreciate the human costs that we've heard about. And I think I just want to acknowledge it's very powerful and important testimony. So I'm going to start there. It's also really important to remember that in these investigations and really the process, that there is someone else on the other end of these incidents, right? And that person may be a perpetrator, that person may be a bystander, that person may be in crisis. But when that firearm is discharged, there is another victim. And to answer the question that was floating around the committee room, what happened in 2020, is it COVID related? Well, I would point you to Act 165 of 2020. which arose out of the awareness of the sanctity of human life and a rebalancing, I would suggest, of law enforcement interactions with civilians. It's the George Floyd moment and the realization around where things are. And that led this body to make pretty significant changes to the standards of use of force for law enforcement that are now held in 20 VSA 2368. And the reason that's important in a lot of these officer-involved shooting cases is that, especially if there's a fatality resulting from the use of a firearm in the course of an officer's discharge of their duty, we look at the 13 VSA, let's see if I can read it, it won't. Justifiable homicide is where I'm going to take us to. It's 13 VSA 2305. That is the statute under which the AG's office is operating. And so I want to really caution, as the committee looks at this, to remember that effectively this is a criminal investigation. And it is a criminal investigation looking at whether there's justified use of force, because if there's not, then criminal charges result. The work that this body did on Act 165 was really to center victims. And if you look through 20 VSA 2368, you'll see throughout, and I would really focus on where use of force lies under 2368B, right, which is the authority of law enforcement to use physical force is a serious responsibility that shall be exercised judiciously with respect for human rights and dignity and for the sanctity of every human life. So part of what happened in 2020 is a shift in how the analysis around appropriate use of force occurred. When we undertake these OIS investigations, officer-involved shooting investigations, the primary focus is on the victim and the victim's experience. The secondary focus is on the officer and the officer's experience. And then the tertiary focus, but very important as well, is ensuring we retain community trust in our law enforcement activities. When we look at placing timelines, and I will say in our fairly cursory review of other states that have timeline, no other state has a timeline. New Hampshire doesn't have a timeline. California doesn't have a timeline. Missouri doesn't have a timeline. I'm not aware of other criminal investigations that have timelines in statute. I recognize, as Detective Crow said, there are practices within law enforcement to clear cases quickly. When we look at these officer-involved shooting cases, we want to ensure that the use of force was appropriate, that it was commensurate with the circumstances that in which the officer found themselves. Most of the time it is. And that essentially we could prove, if charges were to be brought, we could prove beyond a reasonable doubt that use of force wasn't justified. And so we are essentially looking at the investigation with the eye towards a trial, not towards a charge, but towards a trial. So the process, as has been laid out, there is nothing in statute that creates this process. Essentially what happens is, when there's an officer-involved shooting, BSP Major Crimes is made aware of that officer-involved shooting. They contact the chief of our criminal division. She then is involved as that investigation rolls forward. We do not perform the investigation. And I think I've talked about that in this committee in the past, but we don't have, other than ICAC, the Internet Crimes Against Children Unit, we don't have investigators. So we take that file when VSP has finished their investigation, and we begin to analyze it for a determination on whether the use of force was reasonable.
Yeah, Karen, go ahead.
Just with that investigation, and Vermont State Police there's no outcome that they're coming up with. It's just all the facts and information.
That's my
And
understanding.
then hand it off to you.
Yes, and sometimes we seek additional information, training records, other elements that may bear upon, how much past disciplinary incidences, things like that, that may bear upon an assessment of the reasonableness of the use of circumstance.
And I guess I'm just trying to think of the timeline with it, and maybe I missed it. I apologize. This is very new to me. Is there a timeline for Vermont State Police to get that? So that could take days, weeks, months on its own, and then you get it? And is that part of this whole timeline that we're talking about?
Well, I'm not certain what timeline Detective Coro was referring to in terms of the 300 days. I know that and I can go back and sort of ask for a more searching review of sort of what our timelines look like. But we would base our timeline on when we get that first case file to when we issue generally a press release or charges. That's the bookends of our process.
It could have taken weeks or months before that.
It could.
File of
It certainly takes
information
weeks.
gets to you.
It certainly takes weeks.
Okay.
And then we have to do an assessment of the reasonableness. You know, we've talked about experts. My understanding is the longer duration cases are ones where we're seeking engagement with the use of force expert. Those are cases where, based on our initial review of dash cam, body cam footage, witness interviews, it's not clear cut that this was a reasonable use of force. And we certainly clear cases where it is a clear cut reasonable use of force. We just did it last month in a case in Springfield. But when it isn't clear cut, we do reach out because, again, we are looking at, is this a chargeable offense? This case has been handed to us as a potential prosecutor. I should also say the state's attorney is doing a parallel review and analysis of the same materials. As I think was mentioned before, it's not going to be the state's attorney in the county in which it occurred. They'll conflict to another state's attorney. So there are parallel investigations going. And then,
Yeah, go ahead.
Maybe I'm the only one. I feel like I'm just learning. So the state's attorney and your office gets the information and are doing these investigations. Is it that the state's attorney can come up to a decision before you, or like how do you coordinate that? It's like, oh, well, they came to a decision, we haven't yet, and how does that move anything forward?
I should also say, I'm not aware of, I have no firsthand knowledge of these investigations, including any active investigations. I learn about them when they become public. In answer to that, I'm not sure exactly. There isn't coordination. The purpose is to have two investigations.
And looking for the same thing to see if it was appropriate use of force.
And a state's attorney could come to a different charging conclusion than the AGR. Absolutely.
Okay, that's interesting.
Yeah.
It is.
And generally speaking, there's a conversation that occurs before a charging decision happens because it's helpful to have, if they are differing determinations, it's helpful to understand that.
And this is the timeline that we're talking about right now, specifically to you. We're not addressing the state's attorney, which seems like that is a question mark as well. Are they processing there? It seems that's a piece that's not addressed in this.
I would look to the state's attorneys for that. My understanding is, generally speaking, we're on the same track, at least when we announce publicly. And it's usually, I mean, you can look at any of the press releases on the AGO's website and it'll say state's attorney so-and-so looked at it and generally.
I just think it's why wouldn't we be looking at both of them? So thank you for clarifying that.
I don't think, maybe somebody would disagree, we have a problem. And it's a problem we didn't used to have. And for whatever reason, around 2020, and you brought up our new use of force as a potentially a big reason for it. I mean, these guys came from Burlington where, you know, they have an issue with timelines. And the reason I brought this bill forward is because of a case in Rutland. So it's not isolated, I guess, is where I'm going with it. And the way I look at it, I don't know what we can do to fix it. You know, maybe the 90-day thing here is the right way, maybe it's the wrong way, but I guess what specifically in the use of force law that we passed caused it? And from there, how do we fix it?
I think that's a very fair question, and one that I am not, because I don't have experience beforehand. I don't know as I can speak to it. I can certainly try and get someone to come speak to the committee about before 2020 and the changes that the law wrought. I mean, if you look at Act 165, you'll see a lot of additional language added to the use of force statute, and then overlaid upon that is the use of force policy, the statewide policy around it. I think those all added levels of assessment and analysis. I think we also move to a reasonable officer standard, and that shifts how we look at what is justified use of force.
We ended up with an unintended consequence that's putting people through hell.
Mhm.
And the only thing I can compare it to, being that I used to be on judicial retention, and the hell that judges go through at judicial retention. When I was on judicial retention, I had judges calling me in tears. They were so stressed out about it because they're worried about their job, they're worried about their livelihoods, they're worried about their families. Sounds familiar. We resolved those cases pretty quick for those judges, you know, if you want to put, you know, a timeline on it compared to what we're doing for our police officers. So I thought you mentioned maybe somebody in your office that could, you know, feel, have a little more knowledge of what specifically caused it, but we need to fix it. You know, plain and simple, we need to fix it. And one thing that I don't know if we, you know, if this legislation goes forward, one another thing that I don't know if we could put into statutes, and I'm not pointing a finger at you, but
Go ahead.
but the AG's office needs to be better at communicating with people. He knows nothing about what's going on. You know, even if they came forward and said it's going to be another 3 months, at least you know something. You have a timeline, and I think it, you know, again, it's not in the bill, but I think that's probably one of the most important parts of this is communication.
Mhm.
So you know what's going on. I can't imagine being in that situation.
Totally heard. And, you know, happy to respond to any further requests from the committee. The response I would also have, though, Rep. Burdett, is in the infrequent instances where charges are brought, it's really important to remember that this is a prosecutor prosecuting a defendant. And I'm not sure there's another circumstance in which the law would require the prosecutor to inform the defendant on the results of the investigation or the likelihood of charges or the timeline for charges being brought. I recognize most of these cases do not result in charges. Most of these cases are instances of officers well-trained, well-operating, and responding to awful circumstances with the best experience and ability they've got. That's a gift to Vermont. There are those other cases, and that's the challenge is I'm not sure how prosecutors can distinguish there early on and say, okay, I'm going to tell Rep. Burdett it's going to be okay, but we got to go through the process. I'm going to tell Rep. Rachelson, we'll see.
No, but point well taken. So that just I go back to
165.
165. It needs to be broken.
I would probably disagree with that, but
I
think we need
this
to-
gentleman over
well,
here.
we need to fix this process. This is
Right.
what we need to fix. I don't think we need to fix the use of force policy or the law. But, and I don't understand how it's changed so dramatically from, it was a reasonable police officer standard before. I think that I understand there are some changes. You don't look just at the instance of the use of force. You have to look at the content. And yeah, that's going to take more. But what about some other possibilities? Why not consider having a full-time investigator at the Attorney General's office instead of having to wait for experts to have the time?
I mean, I think there are resource constraints are what the timeline really comes down to.
Right.
And so New Hampshire, for example, has a dedicated investigator in this. And I think most other states have some kind of measure. I can't remember whether it was Rep. Harvey or someone else said, you know, what about an in-house, in-state expert? Oh, it was Detective Carr who said that. I think there are lots of additional solutions here. I mean, again, another piece, and it may be playing into the experience you've heard about, is we take them in the order they come in. And if you have a simple one that should be cleared easily, but it comes on the heels of a much more complex and involved case, we're working through the cases as they come to us. And, you know, maybe that's that's feedback I can certainly give to the criminal division, right? It's the same folks who are prosecuting the ICAC cases or prosecuting or assisting in prosecution of other cases. So, it's still just the 5 folks.
Right, so I think it'd be very helpful if you, yeah, it's very difficult for us to put a 90-day period on it, but it's here and it's for us to consider now, but we need to know other ways that this can be fixed, because I agree, it definitely has to be fixed.
Right.
And this is one possibility for it, but I'm sorry, Zach, you had.
No. You are the chair.
Every once in a while.
No. I fully deferential to the chair's line of questioning. And I think, well, one, I don't envy the position you're in, Todd, because I think this is a very difficult circumstance to defend, right? And I think that's one of the things that we keep coming back to is the 300 days, rightly or wrongly, is not really acceptable because you have people whose lives are, totally uprooted and living in turmoil, and it's really, really quite difficult. I think to piggyback on the vice chair's sentiment that he outlined, communication is a really key aspect of this. And I do think that light oftentimes is the best disinfectant to some of these things that are ongoing. But that leads me to, one of the themes that we talk about in this room pretty much ad nauseum is access to justice and expeditious trials and making sure that people aren't living in limbo and their lives are being, they're being tormented by the system that they're looking to protect and serve. And I think one of the things that, not so much that I take issue with, but I think, a discrepancy in the comment that you made is, yes, there probably are no instances where we're requiring, the AG's office to disclose timelines or give progress reports and status, but it also, not very few of those cases are with law enforcement officers that are committed to making sure that we live in safe communities and are serving the best interests of Vermonters across the state. So I do think that it's a little bit apples and oranges to me, because I don't think that law enforcement officers would fall under the same umbrella there. One of the questions I have is about the Nagel investigator. Have you worked with this individual before, or this law firm?
So I don't
You don't do anything. You're not aware of them.
I am aware of the existence. I'm aware that we have relied on different experts over time. But what you're looking for is someone with law enforcement experience, specifically around the training and implementation of use of force, who has Vermont knowledge.
Right.
It's not a big field, and I think we've shifted over time, and I can't speak to exactly why those shifts made.
You have confidence that this person's doing the best job that they can.
I have confidence in the people who are choosing to rely on this person.
Okay. Is there someone in state that you feel like could effectively serve as a expert witness?
I am happy to go back to the criminal division and ask how broadly we cast the net. I have to believe that we would be using Vermont resources if Vermont resources were readily available, but I'm more than happy to ask that question.
Yeah, I think that would be great. And I think, you've been in this committee, plenty of times, and you probably know that my aversion to spending taxpayer resources on pretty much anything. But that being said, if there was a commitment that could be made from the Attorney General's office that there would be expeditious reviews with dedicated resources in her office, that seems like a pretty good use of taxpayer resources to make sure that our law enforcement officers have answers to to these cases. The last thing that I'm curious about is, do you know how many cases similar to the prior witnesses are being processed right now by the AGO's office?
Yeah, as I said, I'm not aware of when they come in. I'm only aware of when we're going to largely clear or charge them. So yeah, again, I can see if I can get a sense of that. It's because it's a criminal investigation, there's only so much information I
understand.
I have access to.
And so in the cases that have been either cleared or charged, do you have an estimation of how long those cases have taken to clear?
I got a very rough sense of like the last handful. I'm aware of one that was 12 months. One that was 7, and one that was 8. Those are all expert cases. And then 2, 3, and 4 months were the other ones that I was aware of. So you can see the discrepancy when an expert is involved.
Yeah, but I think we're approaching another one that's coming up on a year. And I think to, the vice chair's point is that something is obviously broken. But I'm all set. Chair, thank you.
So I'm wondering if
certainly have I missed it. And I think you just alluded to possibly in the past, there's been in-house. So I'm wondering if, what past Attorney General's processes were. I think people are like referring to the time.
Yeah, I mean, so I think between 2020 and now, there have been 3 separate attorneys general, but I'm not aware of any change in the internal process, nor do I think it particularly. It's a fair question that I can ask about, but I'm not aware of any change in internal process for OIS, independent of Act 165, which I just think changed the standard under which we assess these cases.
Is there, I don't know how this works either, but is there like either a bid process that periodically you go out to bid and solicit attorney or
Experts?
Right, that
I'm now casting my mind in a slightly different direction to when I was a civil attorney at the AG's office. And we would largely seek out experts based on their areas of expertise, their experience. Candidly, you also look at who they generally testify for, whether it's defense or prosecution. Ideally, it's somebody who does both because it suggests more even-handedness. But I can ask these questions about expertise. I don't believe it's an open bid process, though.
I don't even mean like you have to go with the highest, the lowest bid, but just more like the aim to, and I don't know if you can have many people on retainer or contract where some of the expectations are laid out to them about time frame or whatever, because I get the balance, and for sure, I can't imagine what it's like to not know. And I don't know if there are, people have talked about communication. There's like, it's limited what you can communicate.
Or even what I know.
Right, which that's good. I mean, I'm glad that we don't know. But I'm just wondering if like others, when whoever goes off to the AG conference, like, hey, how do you keep people,
I think those are fair questions.
Okay, so we need to actually, can you hold your question? This conversation needs to continue, and we need to get some ideas from the AG's office on how to move this. And if that means we need to start begging for some more appropriations on this, we will do that in this committee. But I think that, we're still looking at this, but I think there perhaps are better ideas from given some of the testimony given to us. So we'll return to this. We have a week after this week, and we'd like to put something through. But as soon as you can get back to us.
Yeah, I'm happy to circle back.
Yeah.
Thanks, Tom. Appreciate it.
Absolutely.
Tom and Tom would be the folks that you want to go with. So thank you for the testimony. Thank you
Thanks,
well
Tom.
for your testimony. It's an important issue that we don't have a clear answer on yet, but we'll figure out. So we're going to move to 8:49, and we have 2 witnesses on that. And we'll start with Judge Zone, if you could join us at the chair, and then we'll go to Julio, because I think Judge Zone, I understand, will be pretty quick. All right. And I don't think they're leaving because you just sat down.
I had that effect on him to do. That's okay.
That was an all rise kind of.
I need to leave. Tom Zone, Chief Superior Judge.
Thank you for being here.
I suspect they're not going to feel as though they missed much because the bill is essentially what it does is it becomes a state version of 42 USC section 1983. And there is not much I can say about it because it's the type of situation where obviously it's going to find its way into the courts. I'm sure you've heard or will hear testimony about federal supremacy, removal of cases, federal tort claims, and a host of other things that the courts, whether it's the state or federal courts, will have to rule upon. And so I really don't have much I can offer.
I guess you could have said you submitted.
I was next door anyway.
Have any questions?
So any questions?
Do you think that this could, I'll give you at least one question. So this will create a state right of action where currently there's only a federal one, do you think that this could like increase the number of civil cases that we're seeing in Vermont? And do you feel like the civil division has capacity to handle it? Increase?
Could it increase the number of cases? Certainly. Anytime you create a new cause of action, there may be additional cases. Can the civil division handle them? I would think, yes.
Great, thank you.
I did not read this bill and think that it would cause issues in the courts with us needing additional resources. I think we can handle it.
Great.
All right, well, thank you for that. I appreciate
My pleasure.
coming in and we'll bring you in on something more stuff. So
I think,
I think we have you in next tomorrow afternoon.
I was gonna say, I'm in tomorrow and Friday, I believe.
385 is,
Yes, I will be remote both days, though, so.
Okay, all right.
Thank you.
That's good. So I have actually a draft 2.1, which I've just printed over to this here of 849.
Which one's this?
This is the verse section 1983.
Oh.
And Julio, if you could join us, yeah, if you could just go grab.
Certainly, and could you have it sent to me too, so I can post it?
I absolutely was about to do that as well. And I know I did send the draft to so a little bit earlier, just to add some of the language we were talking about from Tucker.
Communities.
As far as, communities.
What's the bill number?
That's 849. And we're gonna have an updated draft that you just read. But
Yeah,
you
that's
go
great.
ahead and identify yourself for the record and proceed as we are getting the draft, because most of the language we're gonna start with, at least I assume, is already in our current draft.
Sure. My name's Julio Thompson. I'm an assistant attorney general. I'm also co-director of the Civil Rights Unit. Part of the Civil Rights Unit's duties are to enforce Vermont's anti-discrimination laws. We are also involved periodically in national litigation relating to various civil rights issues, and that's part of my experience relates to kind of the issues of federal and state sovereignty and immunities, and likewise. I do not, as a practitioner, defend the state in lawsuits. And the state, is often, I'm not sure how often, officials are defendants in Section 1983 actions. I don't litigate those. And I'm also not a practitioner currently under the Federal Tort Claims Act. So I'm familiar with the Tort Claims Act process, and we touch upon my testimony, but I just wanted to outline sort of the limits of my knowledge and hope that'll be shape any questions that you direct to me. That's my introduction. Would you like me to, Mr. Chair, to start first with your language or with the bill in general?
Whichever way you want to start.
I think I would prefer to talk about the bill in general. I follow, I listened to the testimony that you've had so far, as well as the very helpful walkthrough from Ledge Council present in the room. Good afternoon. I think there are some issues that haven't been addressed or spelled out that I thought would be useful background for the committee as part of its assessment of the bill, both in terms of how it will work mechanically, but also to assess what its prospect for surviving a challenge from either the United States itself on relating to federal employees, or as a challenge in an individual lawsuit should a federal official be sued for an alleged violation of the U.S. Constitution. One and perhaps two of your witnesses previously testified that H 849 doesn't really create any new rights because it's simply enforcing the Constitution. I think I would respectfully disagree with that. Both that it is a new right, which is a right to sue any of 3 million or more federal employees that did not exist before, and to allow a type of constitutional litigation to occur that, in my knowledge, hasn't occurred in U.S. history. That's not to say there's not merit to the bill, but I think it is selling the bill well short to say that it's a mere adjustment to just a mechanism to enforce the U.S. Constitution. It's modeled, the bill is modeled on section 1983, which Congress originally acted as section 1 of the 1871 Ku Klux Klan Act, which allowed, of course, actions against state and municipal officers. It's important for context of this bill to understand that since at least 1871, the US Congress has understood that government officials might violate constitutional rights. From 1871 until today, Congress has never chosen to offer a remedy if those government officials are employed by the federal government. Congress has created other remedies for negligence. So, for example, it's Christmas time and your package arrives damaged or destroyed. You may have a claim under the Federal Tort Claims Act for the negligence of the postal carrier. And there's a specific process for that. You can't go straight to court. You have to file a form that's called, I think it's the Form 95, if I'm not mistaken. It's a 2-page form. Oh, yeah, here's a copy of it. Like Form 95, you have to file that with the post office. You have to allege the facts. The form says that if you're signing this claim before you send it, you're advised that you could be civilly liable for making false statements. The form also says that you could be criminally punished for making false statements. And then you submit it to the post office for their review. They have 6 months to decide whether to act on it, to settle the case or deny the case. And then after that, you have 6 months to go to court. And if you wait 6 months and 1 day, you're out of luck. So Congress, for a common negligence claim that something could happen to any of us, damaged package, damaged mailbox, would be, that's been carefully prescribed by Congress. But Congress hasn't set any standards for what you would do if the allegation for the same package was not that the postal carrier was negligent, but that he was violating my First Amendment rights because I made a complaint to a supervisor about how late his service has been lately. And then my allegation is that he intentionally destroyed the package because I had exercised my First Amendment right to complain to the government, to voice my grievances to the government. Under existing federal law, that example that I gave with the letter carrier and the retaliation for First Amendment, there is no such right. Supreme Court has never recognized in the so-called Bivens cases, has never recognized any First Amendment constitutional claim that you could bring. And so this law would, on its face, permit those causes of action for anyone who claimed that their speech against the government resulted in something that they think was something bad happened to them and they think it was punishment for protected speech or political activity. So that's brand new. There's no telling how many of those cases would be filed. But I would flag that as a significant change to the legislative landscape, and one that the court has, at least in its most recent decisions, by recent, I would say going back 15 years, has cautioned that those decisions are not the province of legislatures, but of Congress. We heard testimony the other day that the Supreme Court has diminished that so-called Bivens common law right, where you can just sue in court for violation of the Constitution, that they've said that's a legislative question. And this is legislation, and so that kind of the suggestion is that therefore it would have smooth sailing because the Supreme Court has said that. But when the court talks about suits against federal officers, it most frequently talks about Congress being best positioned to evaluate what remedies should be permitted when, what the statute of limitations should be, because Congress is in the best position to evaluate the impacts on the federal workforce. Because litigation can affect how zealously employees perform their duties. That's something the Supreme Court said 30 years ago in a case called Harlow versus Fitzgerald. The language that we have from the US Supreme Court seems to suggest, while they don't say that states can't do it, their discussion about legislating these issues has consistently and again most recently been voiced as the role of Congress. There's no Supreme Court decision that I'm aware of where the court has said, we won't create a common law cause of action because state legislatures can do that. I've never seen that. And if there are such cases, I'd be, interested in reading them. I know there have been lines here and there in the last 50 years of the court's decisions where there are references to state court remedies. But in the case of, the jurisprudence, the common law, the Supreme Court over the last 50 years bears no resemblance back then to what it is today. So Bivens was a case, just briefly, just to fill in kind of the background. That was a case that came to the court in 1971. Mr. Bivens was, he was a resident of Brooklyn. Webster Bivens was a resident of Brooklyn, New York, and he claimed that DEA agents broke into his apartment and manacled him in front of his family and brought him to court without any warrant, without any probable cause. He did not have a claim. He pursued a constitutional claim, and the Supreme Court had to decide, knowing that there was no federal statute authorizing a suit for constitutional violations, what the Supreme Court was going to do that. There's a very different Supreme Court Justice Brennan wrote for the court that under the Constitution, courts generally have the right to decide cases and controversies arising under the laws in the Constitution. And the court's thinking back then in 1971 was, well, that gives us inherent authority to fashion common law remedies as judges have in the common law going back to the days of England. And so under these circumstances, we think there should be a remedy. Even if Congress hasn't acted, we as co-equals in government deciding cases and arising under the Constitution, we think we can recognize that claim. That was 1971. There's only been two other cases where the Supreme Court has extended other constitutional rights in the 51 years or 55 years since Bivens was decided. The next case was the 1979 case involving a congressional aide who was working for a member of Congress and received a note from the congressman saying, quote, although she was able, energetic, and a very hard worker, it was essential that the understudy and my administrative assistant be a man. And so she brought an equal protection claim, claiming a violation of equal protection, and Supreme Court using the same rationale. It's a violation of the Constitution. Congress hasn't authorized a cause of action, but surely she should have a remedy. In the last case, it was 1980, so that was 46 years ago, was a case called Carlson versus Green, brought by the family of an inmate who, in a federal prison in Indiana, who had died during an asthma attack where he did not receive medical treatment. And so the allegation there was that it was cruel and unusual and deliberate indifference to his welfare by federal officials in violation of the Eighth Amendment. And the Supreme Court recognized the Bivens action for that violation. In the last 46 years, the Supreme Court hasn't recognized any other cases. On my count, at least as of the most recent decision by the Supreme Court in 2022, is that the Supreme Court has issued 11 different cases where it declined to extend those remedies. And over time, the rationale for the court has shifted from seeing whether there was a remedy that the court had the power to provide to, is this the role of a court or is this the role of Congress? And that's where the court is today. The most recent case involved a Fourth Amendment excessive force and a First Amendment retaliation case happening in Washington State, a case called Egbert versus Boole, where the majority of the Supreme Court said, it's not clear if we decided Bivens today that we would provide the right, but it's a precedent and it doesn't qualify. Extending it to these facts is not appropriate, that Congress is uniquely positioned to decide these issues, particularly whereas in that case, The defendant in the case was a Customs and Border Patrol officer who was accused of using excessive force against a motel owner who objected to his entering his property. And then later, after he learned that the motel owner had made a complaint against him, he allegedly noted the IRS, or alerted the IRS and encouraged the IRS to audit the motel owner, which he claimed was retaliation for the First Amendment activity of complaining. And while the court divided on why there would not be a First Amendment remedy, all 9 justices said that there would not be a remedy under those circumstances because the questions about where to draw the line on First Amendment claims is so complicated, and it could so impact the federal civil service because it would affect all employees, not just law enforcement employees, that was an issue, at least Justice Sotomayor articulated in her concurrence, that was an issue that was left to Congress. There was no suggestion in that court that could also be an issue that was left to state legislators. And so the question, so the environment that we're in is an environment where the Supreme Court is looking at, when you're dealing with federal officers, that Congress is uniquely situated, and we haven't heard anything from them to suggest that state legislators would. Immunities, like intergovernmental immunities, are judge-created doctrines. So it is relevant, I think, and a bit of the legal realism school to try to assess where we think the court would vote, because their issue, they don't have to follow precedent, right? They routinely overrule cases. There's a fair argument that they have implicitly overruled the Bivens rationale. And so I think that picture presents, I think, stiffer wins than have been, I think, portrayed by some of the witnesses. I think it is, it would be challenged, as Illinois is facing a challenge now. And a related issue, which I think is relevant to your amendment here, is that since this applies to both state and local actors as well as federal actors, one way for the committee to assess, their satisfaction, because as I understand it, there isn't much of the motivation for the bill isn't behind state and local actors. I could be wrong about that, but I haven't heard that. It's been more about expanding it towards federal actors. And I've heard plenty of good reasons why people are interested in that, for sure. But if the legislature, wants to include state and local actors and doesn't want to change the law, then it's a good idea to invest the time to make sure that happens, because I can't handicap percentages here, but the chances that a year or two from now, if the Vermont law passes, that the only thing left standing is the state and local provision and not the federal provision, then you'd want to make sure the law is being applied in the way that you want. And so I think the testimony yesterday about adding language, I think, was very helpful. Supreme Court always tells us when we appear before it, their first job is to try to bring into effect the intent of the legislature. And so if your concern is that you want your intent to be effectuated, the easiest way to do that is to state what it is, either in findings, purpose, or in provision. So I think that was a positive development to put in black and white what it is you think you want to have happen. We're talking a while, so I'm going to take a breath and see if there are any questions about what I've talked about so far. I'm happy to talk about any of those kind of bulleted topics in more depth if you want, or in another direction if you'd like.
I thought so. The new language, subsection C and D, is you find that improves.
I think, as I understand C, and D, really, they only really address cases involving state or federal actors. because C refers to people who act only under state or municipal laws. So C doesn't speak at all to the issue of what the court is supposed to do with respect to a federal defendant, which under the statute could include anyone, at least on its face, Congress, the president, the Supreme Court, I believe any person who's acting under color of a statute. So I'm not sure which defendants would be limited or whether there would be qualified immunity addressed to them.
Isn't that covered in D? So as far as,
Well, I mean, I'm not sure. I mean, it could be. The construction of 42 USC 1983 for 150 years or so has only been talking about the scope of immunity as it affects employees of state and local governments. There are federal functions which are not part of state functions that there is no common law on. For example, in the most recent Supreme Court case I mentioned, the multi-owner and the Customs and Border Patrol agent, the part of the Supreme Court's discussion there was noting a special reluctance to create constitutional remedies against Customs and Border Patrol because some of their functions involve national security. There isn't much national security related jurisprudence in Section 1983. There are other Section 1983, or there are other federal court cases involving members of the U.S. military, for example, the armed forces, again, which is not something that would show up much in Section 1983. Jurisprudence that would also include U.S. domestic and foreign intelligence agencies. It would also include licensing authorities, the Defense Department, which I think employs 2/3 of the federal employee workforce right now. So there are a lot of uniquely federal functions, and immigration enforcement, it's exclusively a federal jurisdiction. So we don't have state case law about the scope of immunity for enforcing immigration laws. It's not a state law function. So I'm not sure that there's much limitation there
so should
for
we,
federal officers.
so should instead, on line 3 and 4, looking at page 2, should just be under color of law, not under color of any state or municipal law, to make it clear that be it federal or state or municipal, that the defenses say that they have the same available defenses.
Well, part of the challenge with the language is that Section 19, it's a defense that's available under Section 1983.
Right.
And those, so, I mean, I think you're saying a defense under 1983 is available to a federal official.
Right, correct. I guess that is what it says right now. I don't think you have to change state or municipal law. That's just what the Section 1983 is, but we're saying an action brought under the subsection A of the section, which could be federal or state or municipal, and they can apply the same defenses.
I think courts will still have to decide whether federal officers who have unique authorities are subject to additional defenses based on their status as federal officers. I don't know how you would articulate that, not knowing what the courts would say on that subject. It certainly, it would offer guidance on something like let's say a member of the Capitol Police searching someone's car without a warrant. And the defenses for, let's say, for qualified immunity for a Fourth Amendment violation is that the officer is liable only if they violated a clearly established right. And that's essentially the Section 1983 test for state and federal law. So that may apply, but whether there would be additional immunities that are afforded to, say, members of the State Department or again, other operating, including, immigration authorities, where their functions, the court may say they need to have additional protections. I don't know what they would do there. But I think what you offered there, I think is likely to be an improvement. The other comment I had about C was that it didn't entirely track, and maybe that's intentional. It didn't entirely track Tucker Jones's testimony yesterday, because he mentioned not only in order to harmonize at least the state and local law. So essentially, the only thing that changes is that you can go to Superior Court as opposed to federal court, is that there are under Section 1983 common law limitations on who can bring the scope of Section 1983 cases. So for example, and by scope, we might mean something like if we see a law enforcement officer using excessive force and I witness it, but I wasn't touched, am I able to bring a tort for the emotional shock of seeing that? Those are issues of scope that have been addressed under Section 1983 that are separate from qualified immunity. It's more about who can sue and what they can claim rather than what the defense is. So C does, I think, half of what it appears to do half of what was recommended yesterday.
And I think D captures the rest. I mean, the whole scope issue, I think, is captured in D. Is it not?
I don't know I don't know. And here's why. It says guided by, but not bound by. We do have cases. So one of our duties in our day job in CRU, when the legislature is not in session, is to enforce the Fair Employment Practices Act. The Vermont Supreme Court has said repeatedly, because the language is patterned after Title VII, we are guided by the federal court's construction of Title VII. But in a handful of cases, they've also said, but we're not bound by it because it's a remedial statute and was passed at a particular time and context. And so we think we can go beyond what the courts have said. That's one thing. And two, there isn't uniform. I mean, and I'm not trying to create at all obstacles to achieving what you want, but it says guided and not bound. And if you want it to be guided and not bound, then that's fine. But I think that issue about what guided means will be litigated in court. People will say, you could have said bound, but you said guided it, so therefore the court's free to do what it wants. And you may wish to do that as a matter of policy. That happens all the time. But I don't know that it ensures 100% that there would be absolute harmony between the two.
So what do you think is the biggest litigation risk as far as this not being upheld? Because we had testimony on preemption and
Yeah. Some preemption. I mean, they didn't mention all of the preemption arguments, but they mentioned some of it. There are other ones as well that weren't mentioned.
So what do you think are the most likely arguments that would be toughest to defend on that? I mean, I don't know if I'm saying that right, but.
Well, we do, and as the Attorney General's office, when we defend their laws, we follow kind of.
Well, I guess
Sprezzatura, which is that everything looks effortless, right? So I think that, well, I could tell you a little bit of what's likely to come because, of course, we have a complaint that the Department of Justice has filed against Illinois. I brought it with me here. I mean, one of the arguments that they will make is that by creating a cause of action that exposes individual federal law officers to personal liability for any for any civil constitutional violation, you are essentially affecting their conduct. You are therefore regulating the federal government. You're just using private actors as a proxy for the state, essentially, is the argument that they're making. They allege that Illinois wants federal authorities to change their behavior, and rather than saying that in black and white, where they fear they might be called out on it, they are creating a private right of action for people to go do that instead on the state's behest. That's part of their argument. And in the complaint, they cite some of the Supreme Court cases that talk about the fear of liability can chill all but the most ardent government employees' zeal. And so they are saying it is a form, it's just a masked form of and I think they compare it to, there was a Texas law that allowed private people to sue doctors for for performing abortions or other healthcare services as a way to avoid Texas just having its own flat out ban. So they're making that argument now. They're also making an argument about a type of preemption that hasn't been named, but it's known in constitutional law circles as obstacle preemption, which says even if you don't intend to interfere with government actions, if the effect, so either the purpose or the effect of the state law is to place a drag on federal options and impose a burden on federal options, then that, in an area where historically the federal authorities have legislated, where Congress has legislated, that's a type of preemption as well. It's not that it's just a little more difficult. It's not like you have to cooperate with the federal authorities, but if you are placing various obstacles in their way, making their job harder, then that's an argument that I think the court will be grappling with. One thing I think in terms of what the committee hasn't been doing that it might consider doing, I don't know how, no telling what a court will make of it. But in terms of presenting, a picture of kind of rounded considerations, it may be useful to collect from experts who are not us, information about how litigation affects the federal workforce now. I don't know how many federal tort claims acts are brought, and how that affects federal operations. I mean, I'm just looking to what the Supreme Court said in its most recent decision, or what Justice Sotomayor said, which was that we're not going to draw First Amendment lines here because we don't know how it's going to affect civil service. We don't know how it's going to affect tenured government employees. That's something for Congress to do. I think a challenging picture for the state of Vermont is to come into court. They're challenged by the federal government, or if someone's trying to enforce or defend against one of these lawsuits. Is that a record that says the Vermont legislature never considered the impact on federal employment? If the answer from, I think, some of the academics is that the states are free to legislate because it's not a court function, then I think having a rounded, again, assessment about mechanisms, if there are other mechanisms to address the issue about who could sue for how long, and also there are 15 or more states that are doing this, what the statutes of limitation are. Could our neighbors pass a law that says we have the Vermont law, except there's a 25-year statute of limitations? Well, Vermont's law is, it's 3 years for personal injury. So there could be differing standards. So I think having some of that either in written record or collection of articles or some research like that, I think would be useful. And I'm not that familiar with the other state laws to see whether they've done anything also to address so that the legislature is truly considering the balance of interests that the U.S. Supreme Court has said they expect Congress to do, rather than a state just saying, we're only considered about Vermont's interests, which, but even though it has an unknown impact on the federal government. So that may be useful. I don't know whether it would, whether it would be successful ultimately in litigation, but that's not something we have right now, and it's something I can't speak to.
So one other question. Did you have a question? Go ahead.
Oh, my only question is just to clarify. Supreme Court has said, yeah, this maybe should be in Congress's jurisdiction because they have the understanding of how it's going to impact federal employees and all that. Has there ever been any ruling that has said it shouldn't be something that the state legislature
I'm not aware of the case being teed up in that quite that manner. It's simply been that someone comes to the Supreme Court without a statute to cite,
Yeah.
and asks the Supreme Court to create a federal cause of action. And when the court says, no, we're not going to do that, again, the Supreme Court on a weekly docket is dealing with cases involving the states, so they're no doubt aware of state legislatures. But I'm looking at one case right now which involved another. They decided not to extend constitutional claim against a border officer who shot someone on the U.S.-Mexico border. And the court said, quoting from a case called Hernandez versus Mesa, 2020 decision, we have recognized that Congress is best positioned to evaluate whether and the extent to which monetary and other liabilities should be imposed upon individual officers and employees of the federal government based on constitutional torts. And it's citing another Supreme Court case when it's doing that. So it is, the picture, again, kind of the legal realism picture, and legal realism is a school of jurisprudence. That's not my term. Dates back to at least the 1930s. Is that the picture is of the federal courts making it more and more difficult to sue federal officials for constitutional torts. And then the question becomes, could states now, for the first time, write a law and open up all that litigation that the court, through judge-made doctrine, has says you can't have that litigation unless Congress passes it. I view that as a difficult environment for any law, because the Supreme Court doesn't have to follow even its own precedents. And again, immunity doctrine is judge-made. And so how that would land on a court would say, oh, I don't know if a court would say, oh, you know what, states, you got us. We hadn't thought of state legislatures, and therefore there's no restraints on except for qualified immunity. I'm not sure they would do that.
So how about through an originalism lens? How about the late 1700s and 1800s? Could states have sued federal officials?
There are a few cases where the Supreme Court refers to torts like trespass and assaults, because you can have both, right? Going back to my letter carrier, if I complained to him about late packages, his response couldn't have been to damage my package, but to damage my front teeth. And he might be liable for the intentional tort of battery, which is a common law tort that I could sue him under federal law, assuming that's because the Federal Tort Claims Act doesn't cover intentional torts. Punching someone in the mouth is typically intentional. But I could, under existing law, I couldn't do it under a First Amendment theory. It's possible the court would do that, but I guess the question, I would note that, whether a majority of the court would follow cases from the 1930s saying states could do that, there could be such causes of action, when the court, looking back only 50 years, is saying we wouldn't have even followed what we said 50 years ago.
Well, that's why I'm trying to go back 200 or 225 years.
I guess what I'm saying is that I think part of the jurisprudence that's in the court is not merely looking at the text. There's no text in the Constitution about a cause of action.
Right.
And looking at the history of the United States, a central question in all of these cases are, if these lawsuits could happen, what would happen? And do we know, in Bivens, they thought it would be pretty clear what would happen, because breaking into somebody's house and handcuffing without probable cause, that case law had been pretty well settled for at least, a decade or two. But First Amendment torts and equal protection violations are both based on the intent of the federal actor. So even if you know what happened, you still have to know why it happened. And this is the points Justice Sotomayor made in that concurrence I mentioned. That could involve more entanglement in court to get discovery on why someone did something, even though we all know what they did. And so when we're looking at the cases, the court is very concerned about they don't use the word, although, academics looking at these cases say the court is concerned about a flood of litigation that affects the federal workforce. And so I think that is something, that's why I said I think that having some assessment or information about litigation impacts on federal workforce might be relevant. The Federal Tort Claims Act has been around for generations, and so there's plenty of research about federal tort claims and the like. So, I mean, I think it's inescapable. The court is going to say, okay, if this case went to the Supreme Court, okay, Vermont, if we let this happen, what's going to happen to the federal workforce? And are we going to let that happen? And that's where, and is there room for the court to say no, or we're gonna limit that? There is room for the court, I think, to do that, but the court may be, it's possible the court could be persuaded by a more historicist, interpretation, as you suggested. I just haven't seen that show up in the recent court cases. And so I think that's why I think we all agree that it's uncertain. And I think the professor said, yes, it's at best a guess.
Yeah, no, it's
Just a matter of how much of a guess it is.
well, they're selective, or courts are selective on when to look at history and when not.
And this is a court that has very little respect for precedent, many. So even the decisions they made 2 or 3 years earlier. So I think that's part of the calculus.
All right, well, I appreciate your testimony. This gives us a little time for Tom to be prepared for his big day on the floor.
Big day.
So I thank you so much for your testimony.
Thank you, Mr. Chairman.
I really appreciate it. And just a couple of things. I started an email that I was sent to you all just about tomorrow, but I'll tell you just really generally. I'm going to send an email that has a link, or that will include the document that's the report of the Division of Racial Justice Statistics that they're going to review tomorrow, just in case you decide you want something to read. And will be a link to, so H410 we're taking up tomorrow afternoon. And what that bill does is it defines recidivism, not how the bill is introduced. It's going to be much simpler. And then it's going to set forth three reports, ongoing reports that we want the Statistical Analysis Center, or CRG, to continue. These are reports that were started under Act 40. I will send a link to those three. I think they're actually very valuable and information. One is, one of is recidivism under the current definition, but I want recidivism under the new definition. The second is arrests and cleared charges, which gives you an idea of just crime rate. And then the third is bail, and lots of really interesting data that they collect on bail, which also will be helpful. So H410, I will link to those, to the thing that has those three. So if you have a chance, you can look at them. But this bill will recidivism, and then those three reports going forward. And also potentially, and I'm not sure if this last bit's going to survive or not, but a work group over the summer of the stakeholders to look further at data availability. But that work might be getting done already by the Division of Racial Justice Statistics, so that might not be there. I will forewarn everybody, for the cost of those reports going forward is like $22,500. Yeah, which seems like a bargain to me, given everything else, but there will be that appropriation in there.
So we're gonna see a correlation between bail and crime and stuff now?
I don't know, maybe, but no, at least, well, so at least, yeah, maybe there, I don't know if I don't know if it'd be correlation, or what's the other?
Causation.
Yeah, not causation, maybe correlation, you're gonna see, but not causation. Thank you, that's what I, but what we might be able to see. We might be able to see. You might be able to see the trends in bail, given the changes to our bail statutes that we made and other things. So anyway, I'm going to send that email with those links in case people want to look at it in advance.
So did I just hear you don't have a problem with spending $22,000 a year and you have no idea what you're really doing?
No,
Is that what I just heard?
No, you did not hear that.
No, I think I did.
I want you all to take a look at this data and see, is it worth
You want to hang those on
going forward?
Yeah.
Yeah, yeah,
We're online.
yeah, I know.
Yeah.
Yeah.
I think Vermonters ought to hear the amount of spending that's going on in this building.
Correct. So we can look at
Because if
that.
it's not real in their tax bill this year, it will be.
What's that?
Well, you disclosed.
I just disclosed it, and I also told you where the data is that you can, if it's worth continuing to gather this data.
Can we make suggestions for other data we'd like to put into this?
Bill? I have a list. Of course, give me any suggestions you want, but I've already talked to him about the
It's not
data.
gonna listen. Yeah, and they said no.
It doesn't really fit in here, into this thing, but
Okay.
can be something that will, because this is gonna be more public facing than you're asking for is more state's attorneys. So I have spoken to him about that. All right, we're adjourned till 9 o'clock tomorrow.